All right, Rob Ryder here again. Still on 4B. I want to go back to this one paragraph here. But if the defendant in a seize or action of trespass be desirous to refer the validity of his title to the court rather than the injury, or rather than the jury, he may state his title specially and at the same time give color to the plaintiff or suppose him to have an appearance of color of title, bad indeed in point of law, but of which the jury are not competent to judge, because they don't know what's going on. Only the judge does. As if his own true title be that he claims a fee offment in livery, with livery from A, by force of which he entered on the lands in question, he cannot plead this by itself, as it amounts to no more than the general issue of a seize, or not guilty in an action of trespass. So he can't do it just by itself. But he may allege this especially, provided he goes farther and says that the plaintiff claiming by color of prior deed, without livery, entered upon whom he entered, and may then refer himself to the judgment of the court, which of these two titles is best in point of law. So you're going to take your title to the Chief Justice of the King's Bench, or, again, I'm just going to take it to, and see how this works first, right? The county attorney, whoever was hired to be the prosecutor, not hired, whoever was elected as the prosecutor, is the King's Attorney General. When the plea of the defendant is thus put in, if it does not amount to an issue or total contradiction or declaration, but only evades it, the plaintiff may plead again and reply to the defendant's plea, either traversing it, that is, totally denying it, as in one action of debt upon a bond, the defendant pleads paid when due, that he paid the money when due. Here the plaintiff's replication may totally traverse this plea by denying that the plaintiff paid it, or he may allege new matter in contradiction of the defendant's plea. And when the defendant pleads no award made, the plaintiff may reply, set forth an actual award, and assign a breach, or replication may confess and avoid the plea by some new matter or distinction consistent with the plaintiff's former declaration, as is an action of trespass upon land whereof the plaintiff is seized. So that's why they keep coming after you on these things, right? We're not killing all the bugs. There's three different courts going, and even though you get a dismissed and they come back, well, they're doing this traverse, however the hell they do it. I don't know, but that's what they're doing. But if the defendant shows title to the land by descent, and that therefore he had right to enter, and gives color to the plaintiff may either traverse and totally deny the fact of descent, or he may confess and avoid it by replying that true it is that such descent happened, but that since the descent the defendant made himself demise the lands to the plaintiff for a term of life. So they're going to say, yeah, but you gave me a lease on your body, brother. To the replication, the defendant may rejoin, or put in an answer called a rejoinder. The plaintiff may answer the rejoinder, upon which the defendant may rebut, and the plaintiff answers him, which please, replication, rejoinders, yada yada, on and on and on. God, there's got to be an easier answer. The whole of this process is denominated the pleading, in the several stages of which must be carefully observed, not to depart or vary from the title or defense, which the party has once insisted on. For this, which is called departure in pleading, might occasion endless altercation. Therefore, the replication must support the declaration, and rejoinder must support the plea, without departing of it. As in the case of pleading no award made in consequence of a bond of arbitration, to which the plaintiff replies, a bond of arbitration, again, I believe that's statute staple, statute merchant, setting forth an actual award. Now the defendant cannot rejoin that he has performed this award, for such rejoinder would be an entire departure from his original plea, which alleged that no such award was made. Therefore, he has now no other choice but to transverse the fact of the replication, or else demur upon the law of it. Yet in many actions, the plaintiff who alleged in his declaration a general wrong may in his replication, after an evasive plea by the defendant, reduce that general wrong to a more particular certainty by assigning the injury afresh with all of its specific circumstances in such manner as clearly ascertained and identified it consistently with general complaint, which is now called a new or novel assignment. As if the plaintiff in trespass declares on breach of his close in D, and the defendant pleads that the place where the injury is said to have happened is certainly close to the patch or D, which descends to him from B, his father, and so is his own freehold, the plaintiff may reply and assign another close in D, specifying the buttles and boundaries of the real space of the injury. It has previously been observed that duplicity in pleading must be avoided. Every plea must be simple, entire, connected, and confined to one single point. It must never be entangled with a variety of distinct, independent answers to the same manner. It must require as many different replies, and introduce a multitude of issues upon one and the same dispute. For this would often embarrass the jury, and sometimes the court itself, and all events would greatly enhance the expense of the parties. Yet it is frequently expedient to plead in such a manner as to avoid any implied admission of fact which cannot, with propriety or safety, be positively affirmed or denied. And this may be done in what is called a protestation, whereby the party imposes an oblique allegation or denial of some facts, protesting by the whatever that is, that such matter does or does not exist, at the same time avoiding direct affirmation or denial. Sir Edward Coke has defined a protestation in the pithy dialect of the age to be an exclusion of a conclusion. For the use of it to save the party from being concluded with respect to some fact or circumstance which cannot be directly affirmed or denied without falling into duplicity pleading, and which yet, if he did not thus enter his protest, might be deemed to have tacitly waived or admitted. So we put in a protestation. Can't confirm or deny Jack. Thus, while a tenure in village subsisted, if a villein had brought an action against his lord, and the lord was inclined to try the merits of the demand, and at the same time to prevent any conclusion against himself that he had waived his sovereignty, he could not, in this case, both plead affirmatively that the plaintiff was his villein, and also take issue upon the demand. For then his plea would have been doubled, as the former alone would have been a good bar to the action. So you affirmatively plead that the plaintiff is your villein. If you're the king, everyone works for you, and a villein is a villager. I believe that's what that was, if I remember right. By this means, the future vassalage of the plaintiffs was saved to the defendant in case the issue was found in the defendant's favor. For the protestation prevented that conclusion, which otherwise had resulted from the rest of his defense, and that he enfranchised the plaintiff, since no villein could maintain civil action against his old. So you just tell him, well, he works for me. He's my villein. That's worth checking out a little bit deeper. So also, if a defendant, by way of inducement to a point of his defense, alleges, among other matters, a particular mode of sizing or tenure, which the plaintiff is unwilling to admit, and yet desires to take issue on the principal point of the defense, he must deny the sizing or tenure by way of protestation, and then transverse the defensive matter. So, also, if a defendant, by way of inducement to the point of his defense, alleges a particular mode of seizin or tenure, which the plaintiff is unwilling to admit, and yet desires to take issue on the principal point of the defense, he must deny the cession or tenure by way of protestation and then transverse the defense matter. Okay, so if you allege a particular mode of cession or tenure that you own your body and your land and estate, your all capital letter name, as the lawful owner, if they're not willing to admit it and they desire to take issue, they have to do a protestation. So lastly, if an award be set forth by the plaintiff and he can assign a breach in one part of it, viz. The non-payment of some money, and yet is afraid to admit the performance of the rest of the award, or to answer in general on non-performance in any part, lest something should appear to have been performed, he may save himself an advantage he might hereafter make of general non-performance by alleging by the protestation, and plead only upon the non-payment of the money. Ooh, man, I gotta read this stuff again. In any stage of pleadings where either side advances or affirms a new matter, he usually, or as was said, avers it to be true, and he is ready to verify. So that's some key words there, and he is ready to verify. On the other hand, when either side traverses or denies the facts pleaded by his antagonist, he usually tenders an issue, as it is called, the language of which is different according to the party by whom the issue is tendered. For if the traverse or denial comes from the defendant, the issue is tendered in this manner. And of this he puts himself upon the county, thereby submitting himself to the judgment of his peers. So, if you're going to make an issue, the issue is tendered in this manner, and of this he puts upon the county, thereby submitting himself to judgment of his peers. But if the traverse lays upon the plaintiff, he tenders the issue or prays the judgment of the peers against the defendant in another form, and that is, and this he prays may be inquired of by the county. I have to remember that. I might put that to use here in my letter I'm going to write. But if either side, as for instance the defendant, pleads a special negative plea, not transversing or denying anything that has been before alleged, but disclosing some new negative matter, as where the suit is on a bond conditioned to perform an award, and defendant pleads negatively that no award was made, he tenders no issue upon the plea, because it does not yet appear whether the fact will be disputed, the plaintiff not having yet asserted the existence of any award. But when the plaintiff replies and sets forth the actual specific award, if then the defendant transverses, signifies to deny or controvert anything that was alleged in declaration or replication, the plaintiff answers the defendant's plea. And the replication, the plaintiff answers the defendant's plea and denies the making of such award. He then, and not before, tenders an issue to the plaintiff. For when in the course of pleading they come to a point which is affirmed on one side and denied on the other, they are said to be at issue, all their debates being at last contracted to a single point, which now must be determined either in favor of the plaintiff or the defendant. So you're trying to get it down to one single point. Yes or no. By defending the force and injury, the defendant waived all pleas of misnomer. By defending the damages, all exceptions to the person of the plaintiff. And by defending either one of or the other when it should behoove him, he acknowledged the jurisdiction of the court. So we want to be careful what we're defending. We don't want to waive all pleas of misnomer. Need to look that word up and see what that means. And I hope you're confused a bit, because I know that I am. But, this is what I do, and I go back and read it some more and look at some more definitions and, pray for some wisdom. Lord, just show me the truth and give me the wisdom to see it when I see it. And hope that he gives me the wisdom to understand it better. One of the things I'm going to do after this, I think, I may do one more series on another chapter. But I need to go back and make a flow chart, because we have three courts going, and each of them are using different pieces of paper, and some are tied together. They're like this over here, and then for each of those, there's a remedy. And you know, so it really depends on what level you think you need to know this. Now, the other option is to know that you're the king. Go accept some oaths and see if you can do it. Let your ministers do it, because the king is never legally liable. If they're coming after the king, one of his ministers has made a problem, or one of his ministers has a problem, because he's going to be investigated to find out, how did you make the king liable. Okay, that's it for this. I'm talked out for now, and you all have a great day, and I hope you find it useful. Take care of yourselves. See ya.